I appreciate the warm welcome. Hopefully, I can meet the standards that you've already laid out for us. I would be remiss if I was not a lawyer that had some wonderful caveats to our discussion today. So anything that we talk about today, just so we're clear, is not legal advice. These are opinions and information only. If you have a particular question or an issue that you think is important to address for you, seek out your counsel. I'm also happy to have a discussion after we have this talk. And also just to cover ourselves, this is being recorded and your continued participation is your acknowledgement and agreement to do so. As Jim talked about, we're talking about employment law. Everyone on this call either has been an employee, has been an employer, and is going to have a personal experience about the issues we're going to talk about. So if there's a question, if there's an issue, if there's something that pops up that you say, hey, I want to get that question answered because I'm here right now to help you with that, put it in the Q&A chat. John and Jim are going to help facilitate that. And I encourage questions while we're doing it. Often I find people have these questions, they don't ask them immediately, and guess what? We forget about them and we don't really get that valuable information, because when we engage, we're going to really get to the heart of what you guys want to know. We're going to talk about 4 things today that are really critical to starting a business from an employment law perspective. We're going to talk about compliance, contracts, classification, and compensation, the 4 C's. Now, one of the things, as Jim already alluded to, employment law is something we all have to deal with, but very few of us understand how it all works. We have some concepts, we have some ideas, we apply common sense, and the unfortunate thing in this world is common sense is often wrong. And so what I'm going to try to lay out for you today is some key high-level issues. We're not going to get into the nitty-gritty detail, but we're going to talk through some of those key issues so that you are better educated to identify those concerns and those problems that you might foresee in your business, so that you can be prepared to execute on that and avoid these traps as you move forward and grow. So let's focus on some goals for today. And why is this important? First, legal compliance is critical because it gives you a competitive advantage. I can't begin to tell you how many clients that I talk to, they say, I wish I had done it the right way the first time, because it's much cheaper to pay a lawyer to do it right than it is to fix the problem. Second, when you do things right, you gain trust of your customers, your people, your workforce, your team, your culture. It drives opportunity. And then lastly, when you are compliant and transparent with how you operate your business with your people, particularly your people that drive your opportunity, your business doesn't succeed without your people. When we're transparent about how we're going to handle these issues, it creates a return on that investment. So one thing that's really important, particularly for businesses here in Illinois, is there is a whole gambit of laws we have to worry about. It starts at the federal and goes all the way down to the city, depending upon which cities you're in. And the problem that any business owner has to deal with is understanding which ones apply to them. Let me give you an example. There is a minimum wage overtime law that is both in the city of Chicago, the state of Illinois, and in Cook County. Complicating matters is that the Constitution in Illinois allows for any municipality within a county to opt out of a county ordinance. So the minimum wage Cook County law doesn't necessarily apply in Wilmette, but it applies in Evanston. It doesn't apply in Kenilworth, but it applies in Skokie. These are the concerns and considerations we have to think about, because if you don't know which minimum wage law your business is subject to, you may not be paying your people correctly. And so we've got to make sure we understand which ordinances, particularly wages, are going to apply to your business. So let's begin with the onboarding process. When we bring people and start them with our employment, there's some key things we need to be thinking about. One, handbooks. Everyone has them. No one likes them. Everyone hates doing them. They are super critical to your business, and they are required in many instances for several policies, including sexual harassment, super critical in wage and hour issues, and other problems that we're going to talk about today. Second is contracts. What contracts are important to your business, with your people, with your clients, with your businesses that you're working with? We want to make sure we have those in place. The other one that's a real hot topic that everyone talks about is immigration. Everyone knows them. They're I-9s, super important. Last thing you want to do is ICE coming in for an audit and then have to make you terminate every single one of your employees that you haven't complied with. And then obviously taxes. We got to make sure we have all the right documentation from our employees so that they're taxed right. You're doing your taxes right. You're doing all your appropriate filings for quarterly unemployment, etc. The other thing is here in Illinois, there is some trainings that you are required to give to every single employee. Depending upon where you are, if you're in the city, there's sexual harassment training, there's manager training, and there is bystander training that you're required to give. If you are in the state of Illinois anywhere and you have one employee, you have to offer sexual harassment training. Now, there are other trainings that may be required because of your job. So there are several safety required trainings that several positions require. And so you have to make sure that you're tackling those problems. And many of these laws require that those trainings occur within a set period of time after someone starts. Now, everyone knows about discrimination, retaliation, harassment. Now, when does it apply to you? Well, guess what? You're in a wonderful state of Illinois, which means you're over-regulated. And any business with one employee is subject to these laws under the Illinois statute. There's also a federal equivalent, which has very similar laws, similar requirements. That only kicks in if you have 15 heads on staff. Now, one of the questions I often get, well, what do I do about independent contractors? And those aren't my employees, right? I don't have to count them. Well, we're going to talk a little about that later. It's one of the biggest problems that business owners fail to do, which is classify their people correctly. Are they an employee? Are they an independent contractor? That question, unfortunately, is not decided by you or your employee or your contractor. The law says we don't really care what you say. What we care about is what you do, how you do it, who controls it. And we're going to talk through those issues. So one thing that can kind of bite people on this number of employees is, let's say I've got 10 employees, but 6 contractors. You're like, I don't have to worry about the federal laws. You might have to worry about those federal laws because those 6 contractors truly are actually employees, and therefore you're subject to the federal rules. Now, everyone generally knows what discrimination is, but let's just walk through a few things so that everyone understands. It is the practice of engaging in a negative, unfair treatment towards a protected group of people. Here in Illinois, it could be parental status, it could be your race, it could be your gender, it could be sexual orientation. We know what those are. It could be medical, it could be disability, it could be religion, it could be national origin, it could be military. All of these things we all know about. And the discrimination of these actions can apply in every single step of an employee's lifeline with a business. So it begins when they start, continues when they train, how they get promoted, what they get paid, how they get paid, the job opportunities they get. And then it goes further down and how you're going to give the opportunities. Who are you going to train to become your next manager? And then finally, we've got to make sure that once they're on site, we're doing everything we can to prevent harassment, discrimination, sexual harassment, all these things we know about, we hear in the news. As an employer, you have an affirmative obligation to prevent, correct, and ensure it doesn't happen on your workplace. All right, I'm going to walk through just a quick little story about some discrimination, and we're going to do a little bit of Q&A. I would like to get some answers, so if you have an answer when you hear this question, spit it out. I want to see, make sure everyone's paying attention, all right? So first, we're going to start with this hypothetical. Kim was born a male, but identifies as a transgender woman. While being interviewed for a job at Acme Stay Inc., she was asked whether she was a Christian. She chose to keep her transgender status to herself. After working, she was encouraged by her coworkers to be herself, and as a result, she came to work in clothes designed for women. She was mocked for dressing like a girl, and as a result, she reported the harassment to management. All right, first question, and I promise this is an easy one. Is Kim being discriminated? We can get one answer, I promise. Come on. Come on. No one's going to answer. Okay, fine. Then I'm not going to help you. All right, in a response to that complaint, the manager said, I don't want a transgender person here. If you're going to do that, I have to get rid of you. After complaining, she started receiving unwarranted write-ups. Anyone think that she might be getting retaliated against? I got Donald on the Q&A. We got a yes. Or can the participants not talk? Maybe that's what it is. Donald, thank you. You are correct. She is being discriminated against. She's also being retaliated against. Now, why is she being discriminated or retaliated against? Now, and also so that you guys know, this is based off a real case, so I'm not making this up. She is being discriminated against. Why? Because of her gender status. And recently, the Supreme Court just clarified that question. There was a dispute as to whether or not someone's sexual orientation qualified as gender discrimination, and the Supreme Court affirmed that it does. Now, the rationale is why. The comments and statements that were made towards her and the clothes that she was wearing were directly related to her status as a transgender male identifying as female. And then why was she being retaliated? Well, she received threats of adverse employment action. Her supervisor said, if you're going to do this, you're terminated. That is clear-cut retaliation. Retaliation is the engagement of an activity which any reasonable person would determine is a threat to their job and discourage the protected conduct they were engaging in this case, coming to work dressed as a female. All right, that's our first kind of section. We got any questions? We're going to move on to contracts, but I'm going to open it up. Anyone have any questions right now? And it looks like we're good. We're good. Oh, Robin, I got a question from Robin right here. I see a hand up. Can Robin talk? Maybe not. All right, well, then in that case.
I didn't have one. I'm sorry.
I just see a hand up. Okay.
No.
Sounds good. No, it's all good. All right, then let's move on to contracts. So everyone knows these contracts that we're talking about, but we're going to walk through some really important ones for new businesses. And I will tell you, this is probably the slide that is going to find yourself in the biggest trouble long-term, particularly if your business grows and is very successful, if you don't get it right the first time. Because these are contracts that are designed to protect what brings value to your business and allows you to grow and make all the money you're trying to make. If we don't have these things in place, you are going to find yourself in a place where you are potentially unable to protect your information. So we're going to begin with offer letters. Pretty simple. The first time we're hiring someone, we're going to lay out their job and we're going to walk through all these things. Second, employment agreements, the non-competes. Everyone doesn't like to talk about them. They're super important, particularly non-solicitation. Confidentiality and then protecting your IP. Those last two are probably your most critical that every business needs to be thinking about, particularly with so many businesses now creating IP, SaaS applications, mobile applications. We want to make sure we're protecting those. So offer letter, first document that you're going to give to your people. What do we want to think about it? Well, the first thing, and many people don't realize this, offer letters are enforceable. They're a contract. They're considered a contractual arrangement. There is a give from the employer. I'm going to give you A, B, and C. And there's an acceptance by the employee that I'm going to accept A, B, and C. And then there's what's called consideration. The employer is giving something of value and the employee is giving back something of value, their time. That's what we call an enforceable contract. We want to put in the offer letter those things which are key to the terms of your employment. That's usually going to be compensation, salary. You could include PTO and vacation, maybe even benefits information, but anything that is critical to the employment relationship you want to have situated in that offer letter. And putting aside the fact, the legal considerations, the offer letter is really important because it lays out the first communication from employer to employee of the expectations. And as anyone knows, it's really important to put the right expectations of a relationship on the table immediately so that when the employee starts, they know exactly what's expected of them. And if there's issues, everyone's going to go, hey, you know what? We talked about this. This is what we expected from you. You're not doing it. And here's my offer letter. And I told you exactly what your conditions of your employment, your job duties, your expectations. These are important documents. Now, one step up from an employment offer letter is an agreement. I would focus these documents only on super critical key people. So give you an example, company that sells telco IP solutions to companies that are looking to apply a voice over IP solution. They've grown, they're doing great, but they want to hire their first VP of sales, first key non-family, non-friend employment hire that is going to drive success. That's someone we want to put in an employment agreement. Now, what's different about an employment agreement versus an offer letter? Well, first of all, it more formalizes the relationship and is in line with the seriousness of that hire. Second, it's going to have these critical components that we're going to walk through after these slides, but it's going to have confidentiality, it's going to have non-competes. It also may have protections for severance, may discuss bonus, commission. Another common thing we see a lot with businesses is quote unquote phantom equity, where we give incentive equity opportunities to these employees where you create a buy-in for these key employees where if the company is super successful, they're going to get an opportunity to take advantage of that success should there be an exit, a sale, where we sing a lot of these businesses and what they're focusing on. Now, if we don't have a key employee, there's still some really important agreements that businesses should be considering requiring all of their employees to sign. There's restrictive covenants, there's confidentiality, and there's IP. Now they're different and they have different requirements and different rules here. Jim and I were talking a little bit in preparation for this, and he was reminded that restrictive covenants are kind of in a unique position right now in Illinois. There was a new law that was passed that went into effect January of this year that set forth specific requirements that a business owner must meet to ensure that it is enforceable. And those requirements are really quite interesting. So first of all, for you to be able to enforce a non-compete against someone, they must earn at least $75,000 a year. Second, if you're going to do a non-solicit, they have to earn or anticipated to earn at least $45,000 a year. So if you have low paid employees, they can't be subject to a non-solicit. And if they don't make 75K or more, they cannot be subject to a non-compete. In addition to those salary thresholds, there's a few other interesting ones. First, in Illinois, you've got to provide something that's called consideration. Consideration is a requirement in any contract, but the statute says there must be special, unique consideration given to the employee in exchange for signing a restrictive covenant. What does that mean? That could mean an additional bonus, that could be tied to a promotion, that could be some additional compensation, whether it's an incentive agreement or an employee stock unit or a stock appreciation right. It could be the one you see a lot in Illinois is $1,000 signing bonus. Anything that you give to the employee that is valuable will qualify. Now, the question I get all the time is, well, okay, we'll give them $100. We don't know what is enough in Illinois because the law is relatively new. But the consensus is it needs to be meaningful. What is the employee going to consider something of unique value? Now, there's non-compete versus non-solicit, and let me walk through what the differences there. Non-compete is more broad, more general. You can't go work for a competitor. Typically, it needs to be limited to not just a competitor, but can't be a competitor working in the same or substantially similar position that you're in. So there's something that's called the janitor rule, which is that if it says you can't go work for a competitor doing anything, that's going to be too broad, because if I can go work as a janitor at a competitor, that's going to be unenforceable because it's too broad. And anyone can accept that if a document says I can't go be a janitor at a competitor, that's probably not okay. Now, non-solicit is probably the one that is most important. And that's going to usually be broken down into three key things. Non-solicit of my employees and contractors, this being the one everyone worried about right now, because talent is the single biggest hurdle for businesses to succeed right now. Non-solicit of my customers or clients, and then sometimes non-solicit of my vendors or key relationships. So you bring in a product from China and that vendor or manufacturer relationship is critical to your success. Now, confidentiality is a little bit different, but also equally important. And often when you have to enforce a covenant, you're always dealing with confidentiality as well. Confidentiality is something we all understand and appreciate, but it's really important that we clearly define it. There are lots of contracts that you can find online that just use very broad definitions that say, anything that is special or unique to the business or information about the business, that's confidential. Well, the law and judges don't like that. It's too broad. We need clearly defined examples of the type of data, type of information that's important to your business. It needs to be tailor-made to what you need to protect. The other thing that's important about confidentiality agreements is every employee needs to have them. Why? Well, one of the standards for evaluating whether or not something is subject to protection as being confidential information is, did the company take appropriate steps to protect it? And one of those key questions is, who was subject to restrictions? And if there's employees that get access to the data but don't have those restrictions and don't have a confidentiality, you find yourself in a difficult spot where you're trying to argue that something's special, but you didn't take the appropriate steps to make sure someone didn't steal it or use it inappropriately. And that's another important key consideration in the IP protections. What is IP? This is stuff you create that's the secret sauce. It's what gives you that advantage in the marketplace, something that is unique that you've created that no one else knows, and it's what makes your business thrive. It protects those developments. It also ensures and protects, let's say you have an employee that develops a brand new product. Well, if you have an IP protection agreement in place, an assignment agreement, they have to give you that product. If they've made something, it becomes yours. Otherwise, if we don't have this laid out, that employee can take what they've created and make their own business and take it from you, and you don't get the opportunity to protect that. This includes not only things that they create, but also any invention. So if they've created an invention, we want to make sure that there's an appropriate way for them to assign that invention to you. And then if it's patentable or those sorts of issues, that you can do that. And the employee has to work with you in that world. These are, if there's a slide that I think is important for small business owners to take away from today, this is it. It's easy to do, relatively inexpensive to get a document ready to go with a lawyer, but super critical, because the last thing you want to do is have an employee that there's a breakdown with, they take all your super stuff and you can't protect yourself, and you find yourself without a business and an opportunity to thrive. Do we have any questions, any examples? Anyone want to share some stories about some problems or things that they might be having in this with regard to contracts? It looks like you guys can't talk. Donald just asked, how long is a non-compete legally enforceable? Fantastic question. The answer is I have no idea. Very lawyer answer for you. You know, it really depends. When we're looking at the enforceability of non-compete, it comes down to the reasonableness, and the reasonableness of a non-compete will depend upon what's protected. What's the company have a legitimate business interest in maintaining that doesn't go to a competitor? And so, you know, you can see non-competes that are as short as 3 months and as long as 5 years, and they all can be enforced. Now, I would say as a general rule, over 1 year, you're treading into waters that I would consider uncomfortable. But there may be compelling reasons. So an example of where anything longer than 3 months is bad is traders. So financial traders that are high algorithmic trading that use these complicated algorithms to make money on the stock market. Anything over 3 months is generally too long. Why? Those algorithms, those models that they use to make money on the stock market doing this high frequency trading, they get stale after three months because you constantly have to evolve and innovate. And so by the time you get past 3 months, they're no longer important. All right, it looks like an anonymous attendee. How might what you shared apply to virtual assistants we hire as our IRR, and how would your answer be different from the first hiring be from the US affiliates where it might be less enforceable? So when it comes to these contracts, if you're hiring people that are not in the United States, good luck. The unfortunate thing is that, you know, we can't expect, or you can't expect, that these covenant agreements will apply to someone overseas. So if you get talent through a Philippines, I have several clients that have employees in Nicaragua, I have a few in Honduras. You know, the reality is you can't expect that these agreements are going to be enforceable. Now, that doesn't mean you don't do them, because, you know, people don't always know that. And second, when they sign an agreement, you know, people are usually pretty good. They intend to comply. They don't intend to not follow through on these agreements. And as a result, if you have them sign a document that says, I'm not going to do A, B, and C, most people genuinely intend to not do A, B, and C. The other thing is, if you're working with someone in getting employees in Philippines or Nicaragua, depending upon how many you get, often clients, they engage what are called PEO, private employer organizations, that are located in those jurisdictions, and they can help guide you on what protections you can enforce or get with those employees that are located there. One thing, and I've got a couple clients that deal with some pretty sensitive IP, you know, the key thing when you're using that kind of talent is you want to make sure you are limiting what information they get access to, so they only get what they absolutely need to perform their job. So that if there is some sort of inadvertent or intentional disclosure overseas, it's limited in the scope of the harm it potentially could have against you. All right, I am going to hold on. What if the person we hire as
Walker,
yeah,
we have a couple more questions that are in the chat.
go.
One from Rod on confidentiality.
I'm looking around. I've seen anything reasonably concerned. That is too broad, John. Courts, particularly in Illinois, are going to say if it's anything reasonably considered confidential or something the parties consider confidential, generally that's going to be too broad. Now, if it's in a business to business relationship, not an employee to employer relationship, that would probably fly as an appropriate term or definition of confidential information. But in the employment context, it needs to be more clear than that.
Yeah, I think he's asking about a contract between you and your bank.
Oh, I'm sorry. I have a private message from John that I was answering.
Oh, okay.
Now I got it. Okay. Does your bank have a contract to protect your business accounts? I'm not sure I fully understand what you mean by that, Rod. But does your bank have an obligation to protect your assets in your bank accounts? The answer is generally yes. Bank accounts are, banks are subject to several regulations, some of which is to make sure that the information is not disclosed inadvertently. But Rod, I'm not quite sure I understand it, but you'll see my email after this and let's connect and I'm happy to address it offline with you. And then Robin, are there some basic things that all businesses should do to show that they've taken appropriate steps to protect confidential info stored electronically, like in a CRM, a customer relationship management system? So the answer is yes. First and foremost, as I've already alluded to, is making sure you have a contract. If you can say, hey, all my employees are under an agreement, that cannot begin to tell you how effective a fact that is if you're dealing with litigation. Second, from a CRM perspective, you can limit who gets to see what. So let's say you have a sales team that has regional restrictions. So Johnny gets the Midwest, Maryland gets the Northeast, and Joe Schmo gets Florida. Make sure that they're only seeing in that CRM the people, the contacts that they have to engage with. So they can't go to Florida and take your data. They can't go to Northeast because they don't have it. So one of the things that's really also helpful is just limit who sees what, when, and where. Another question, what if the person we hire as an employee lives in the US outside of Illinois? A question that I have to deal with all the time. COVID, as everyone knows, has developed a unique opportunity where businesses can find talent, not locally, but anywhere. Usually it leads to better people, cheaper usually for the employer too, and a win-win. So what do we have to do about these agreements? Well, the reality is sometimes you have to modify them to the state in which they work. It's a big dispute that there's not a lot of clarity on. But best practices is that you should assume that the state in which they reside, where they're performing the substantial portion of their work, that's the law that's going to govern. So if you're in Illinois, but you have a Florida employee, guess what? You get to apply Florida law to that employee, which is going to be better for you because Illinois tends to be more pro-employee. Now, one thing to think through, just as an aside tidbit, more and more states are requiring and being very aggressive for businesses that hire employees in other states, requiring them to register to do business in the state in which they have an employee residing, i.e. they want to make sure you pay them taxes. Businesses are starting to see more and more audits from states where they have employees but aren't registered to do business, and so at the end of penalties and interest for failing to pay taxes that the state determines they owe because they have an employee residing and performing services there. All right, I'm going to move on to the next section, which is classification. Now, classification, if I was going to pick an area where employers get sued the most, both from businesses and from the government, this is it. The key classification question is exempt, non-exempt. Are they an independent contractor or are they an employee? Now, we've already kind of talked through the second one a little bit, and I'll go through a little bit more examples of that. But exempt versus non-exempt is probably the single biggest one businesses and employees get wrong. First, what is it? Exempt, non-exempt is a question as to whether or not someone is entitled to overtime. And that analysis is much more complicated than what most people think. I would say the average layperson says, if I am paid a salary, I don't get overtime. I'm going to tell you right now, that is dead wrong. Getting a salary is one part of the analysis of a two-part analysis in which both must be true. So if you have a salary, but you don't meet that second test, which is an analysis of what you do, what are your job duties, and does that qualify for one of the exemptions, you will fail this test. And the problem with the failure on this is that if someone is deemed paid salary, but inappropriately classified, you now owe them overtime for all the time that they have worked in excess of 40. Now, I often get this question, well, how do we prove that? How do you find out? Well, there's this law that the Fair Labor Standards Act, which passed, I think, in the early 40s. The big case that went up to the Supreme Court was Mount Anderson versus Clemens, 1948. And the employer said, hey, court, he doesn't have records. He can't prove how much you worked. So how's he going to win this? Supreme Court said, that's funny, employer. You have an obligation under the law to keep those records. And as a non-exempt employee, you were required to keep time in, time out data about the hours you worked, but you didn't because you classified them wrong. We're not going to let you, employer, take advantage of your mistake to follow the law. So as a result, the employee over here gets to estimate the hours that they think they worked. And as long as it's reasonable and based off of just a reasonable inference, it's going to be accepted. And then the employer can come back and explain why it is unreasonable. But if you fail to maintain those records, an employee suing you for overtime gets the opportunity to literally guesstimate what they think they're owed. And more often than not in this litigation, those are very compelling and you're going to have to handle that. Now, the other job duties test, which is the one most people don't think about. There's three major ones that we have to think about as businesses typically, although there's 26 of them, three major ones. Executive. I am someone that manages people. I hire, fire, and manage the work of at least two people, and my decision in how they perform work is meaningful. Second, administrative. I'm in a job performing tasks which are key to the function of the business, not the services we offer to our clients, but key to the function of the business. Accounting, great example, in which I exercise independent judgment and discretion in matters of significant importance to the business. The third one is professional. I am engaged in an activity or a service in which I am considered a professional. Teachers, dentists, doctors, lawyers, someone that has to get a job, a degree, a training, an authorization from the state of Illinois Department of Professional and Financial Regulation. Those are professionals. And then the fourth one I should mention that is the computer exemption, the geek exemption. So it's people that deal with coding, high level engagement with computers, not someone that's doing tasks like help or networking, but someone that's engaged in the code. Those are also exempt roles. Now, the big difference, and I've already talked through this, is if you're exempt, no OT. You get paid your set amount, irrespective of how much you work, how the work is. You get paid what you get paid, guaranteed each week. There's some exceptions to that, but that's the general rule. The non-exempt is that if someone works 40 hours or more in a work week, you got to pay them overtime. It's pretty simple. And we're going to walk through a little bit more of that in a sec. The other big one is independent contractor versus employee. Many small business owners want to drive the decision of the people they hire to be independent contractors. Why? Simpler. You don't have to do unemployment. You have to do workers' comp. You don't have to deal with withholding taxes. Simpler. Usually pay more, 30% higher, more for your independent contractors, but it's generally considered a simple analysis. Well, I will tell you right now that 30% cost and the simplicity of it will bite you. Why? We live in a state of Illinois which is dreadfully poor. The single biggest, in my humble opinion, way that they are trying to find money with businesses, particularly small businesses, is unemployment audits. What they do is what happens, particularly when COVID hit, an independent contractor that you terminated, they go and file with the Illinois Department of Employment Security and say, hey, employment security, I lost my job. Give me some unemployment. They look at their analysis and data they have. Well, you're not an employee. Your employer didn't pay anything for you to be part of the employment system. Why should I pay you? They go back, and employee that's filed said, well, because I'm really an employee, I was misclassified. Guess what? Unemployment says, employer, we're going to do a big audit. And they give you this like page of like 26 things you got to apply and show them and explain. And Illinois Department of Employment Security determines just about everyone is supposed to be an employee. And at the end of that day, you got to pay back taxes and penalties and interest, and it's not fun. The other thing about this thing is it can also be the one that finds you in a wage and hour claim, someone claiming they're entitled to overtime. Because the other reason why people treat people as independent contractors is because they don't have to pay them overtime. Well, someone comes back and says, that's not correct. You did that wrong. Pay me overtime. Now you got to pay them overtime essentially. How do we determine whether or not someone's a contractor versus employee? It really comes down to control is the analysis that really matters the most, which is who is dictating the location, the type, where, quality, et cetera of the work, and who says you're fired and not fired. That's going to really determine this. Unemployment has even a more extreme view, which is that person independent? Are they servicing similar businesses doing the same services? And this is a big one that they like to follow. Is that business a type of business that requires them to be registered or licensed with a city, state, or other ordinance that shows that they're actually engaging as an independent business? All right. I'm going to stop here really quickly. I don't think we have any questions, but John here has been kind enough to look at some other questions and answer the issue on the banks. Any other questions on the analysis we just walked through? Otherwise, I'll go into compensation. Looks like we're good. All right, compensation, really important one too. Actually, all these important. I think we have a, hold on, let me go. Given business owners are juggling many things, they likely will need to contract work out done by a certain deadline or performed in a way we prefer. But this sounds like an employee based on what you said. I would say that's generally correct. But here's the difference is common area where I have clients that engage contractors is, let's say you need to create a graphic image for a marketing campaign or whatnot. It's not uncommon that someone that does that type of work, you're going to give them a deadline. That's fine. You're going to give them parameters, but you're not dictating when they do it. They can do it at 2 a.m. You don't care. They can do it at 7 a.m. in the morning. You don't care. You just say, I need this done by this date. Good to go. And typically graphic designers, those type of people, they're doing that work for several different businesses. Lauren asked, does an independent contractor have to be a business? No, but is it best practice to ensure that they are a business? Yes. So one of the things that we will do with our clients if we're creating a contractor business is ask that the people that are being engaged for an independent contractor set up their own LLCs. And then is it just reps? All right, so if we need someone to come on part-time to facilitate our events at a certain time, does that only make them a part-time employee? That's a complicated question, where you need them on like certain project base. I would put this that, so let me use an example of a real life issue. So I had a client that did catering in the city, you name it, the type of businesses and type of events they'd cater, they did them. And as is standard in the business, cooks, servers were independent contractors. And there's actually online services where you post work that you have coming, employees like Upwork, other things, so you can say, hey, I'll go to that event. I'll be a server, I'll be a cook. And my client treated them as an independent contractor. They lost at the unemployment department. Now, I want to be clear about this independent contractor issue. What makes it so complicated is there's what unemployment will say, who's an employee. There is what the courts will say for purposes of overtime and compensation. And then there's a third entity that we have to worry about in this analysis, and that is IRS. So all three of those, unemployment, courts, overtime, wage and hour, and IRS, all three of them look at this in different ways. Unemployment being the most pro-employee, IRS being the most pro-business. And so that analysis is a little bit different. But in that case where someone was just having someone cater to be a server for 2 hours on a Saturday, the unemployment security department here in Illinois determined they were employees. Now, I would propose to you, I think we'd be very successful in arguing that they are not employees for purposes of overtime and compensation. But in that situation, though, what I think the employee could have done better is created appropriate contracts and agreements that laid out the independent contractor relationship, ensure that that in that case, those people could choose to not come or to come whenever they wanted. There was no requirement, hey, if I give you a job to cater at this particular business or to facilitate this event, you can say no. There's no obligation, you have to be there. That's a key kind of analysis that's important. Michael asked, why is the IRS considered most pro-business? The reason is because it's a 20-step analysis, and it's much more involved and complicated, and there's a lot more give and take. Plus, you have to remember, Michael, that we are in the state of Illinois, and the state of Illinois tends to be much more pro-employee, even versus the IRS. The other reason the IRS is more pro-employee, you have to remember, for independent contractors, the IRS cares about their 15% on FICA, Medicare, those issues. They get paid it. The employee, if they're an employee, they pay 7.5% in their W-2. The employer pays the other 7.5%. If they're an independent contractor, they're paying the self-employment tax. So at the end of the day, IRS is still getting paid their 15% no matter what. So it's not as big of a deal for them from a financial perspective. All right, I'm going to move on because I want to make sure we get to this last part. All right, key issues in compensation: minimum wage, overtime, bonuses, and commissions. Minimum wage, everyone knows it, but understand that minimum wage, as I've already alluded to, is different for on federal, state, county, or city. City of Chicago has one, Cook County has another, state of Illinois has another, and federal has another. Now, benefit in Illinois, we don't have to worry about the federal, because if you're state, county, or city, it's always higher. You always have to pay the highest one that applies to you. So if you're in the city of Chicago, you're dealing with the Chicago rate. If you're in Evanston, you're going to do the county rate. If you're in DuPage County, you're going to do the state. So it's important that you know exactly which one requires. Now, the nice thing is all of the minimum wage issues, they're updated, they're online, but the state, county, and city right now in the Illinois are all tied to CPI indexes, so consumer price index. So they do change, and they typically change July 1, which is the fiscal year of the state of Illinois. Now, overtime, I've already talked through this, but let's walk through why this is so important. First, basic rules here in Illinois right now, it's just time and a half for all hours worked excess of 40. One caveat, there's been some questions about employees working in other states. There are states that do have requirements where overtime has to be paid if someone works, say, over 8 hours in a day, over 12 hours in a day. If they work in that state, you've got to apply those overtime rules for that state. The big one is, how do I determine what I have to pay them? What's considered work? You know, conceptually, we generally understand what that means, but the law, which is really funky in how they describe it, it's really, is the employee suffering or permitted to engage in work? That is, are you requiring them or are you permitting it? So both are considered work. So great example, City of Chicago. There's a case that went up to the appellate court down in Chicago. The supervisors on the police force had BlackBerries. This is when it was new. And they were checking emails, responding to emails, checking texts, those sorts of things. And there's a lawsuit filed that said, hey, I should be paid for this, you know, responding to these emails, you know, doing this type of work. It's work, particularly to a supervisor. Supervisor knows it's happening. They're asking for it and it's being responded at off times, 8 a.m., 9 p.m. Is that work? It was very clear in those type of examples, that's work. So similarly, one I see a lot, particularly in the medical industries, say nurse, performs services, does their nurse services, but then there's note or record keeping obligations. Often what happens, I don't have enough time, you know what, I'll just bring it home. I'll do it, sit down, watch my House of Dragons at home and finish my medical reports. That's work, probably compensable. So one of the things that's really important if you have hourly employees is putting appropriate parameters around when they're supposed to do work and not to do it at home. And if they do it at home, they've got to ask to be paid for it. That's where we get this off the clock issue. Single biggest reason why these cases get sued. Another example, let's say you have a truck driving company where you do moving. You have your team come in, get on their trucks. They drive to their first location. Several moving companies do not start to pay their movers until they get to the client's location. Is that time from getting to picking up the truck and driving to the location, that time driving, is that compensable? Difficult question. There's good reasons why it would be. There's good reasons why it's not. Generally, the answer is it's probably compensable work. And you find yourself, they're in the city of Chicago and they're driving 2 hours to Buffalo Grove. You just have to, that's 2 hours of time you have to pay someone. Overtime is the single biggest common reason why employers get sued. It's the easiest one. It's the one where people also screw up. Had a client yesterday, has people that they're paying probably in a little unusual, not compliant way. And they're like, but the employee loves it. We don't want to force them to do these things. It's a win-win. And my comment to them is, you have to make the decision that's best for your business. But if that employee who right now is super duper excited, super happy with this arrangement, suddenly turns on the dark side and doesn't particularly like it, guess what? You find yourself on the losing end of a lawsuit, and it does not matter if you and the employee agreed to it. Doesn't matter. The other problem with these types of lawsuits is the amount of damages it creates. So let me give you an example. So you don't pay someone appropriately and it's $100 a week. All right. So you owe them $100. All right, that's simple. In Illinois' minimum wage law, there's treble damages. So that $100 now becomes $400. Under federal law, there is liquidated damages. So that is double. So that's an additional 100. Now you're at 500. If you're in the city of Chicago, they also have treble damages. So that's another 200. So that 100 becomes $700 for that week. Now, as you can imagine, these violations tend to happen not just in one isolated week, but in every week. Someone works 50 weeks in a year, that's $700. You just found yourself at the losing end of a $35,000 claim. Now, let's say you're a business with 10 employees and they each have been underpaid in that way. That $35,000 claim becomes a $350,000 claim for a single $100 violation a week. It's really important we get this right because getting it wrong is expensive. And between what I deal with my clients on these issues, if we get a claim that is meaningful, that we have risk on, we settle these because they're going to pay a lawyer far too much money than it's worth to litigate and fight over this because the downside is too high. Because not only do you pay that $35,000 employee, you pay their lawyer's fees because you lose, and you pay your own lawyer's fees. So getting this issue is super duper critical. Commissions are another big one. One, and super important, it needs to be in writing. The last thing you want to be doing is arguing in litigation over what someone is owed for commissions. And there's only one good way to do it, and that is to put it in writing. I don't want any handshake deals. I don't want any promises. We need something in writing. Because if someone gets upset, you want to point to a document and say, hey, Jimmy, you got 8% of gross profit, not 10. And here's where you agreed to that, or here's where I told you what it is. So, because the nice thing about commissions, they don't have to agree. You as the employer, it's an employment of will state. You can tell them you're getting 8%. They take it or leave it. If they leave it, they're gone. They leave. It's pretty simple. The other thing about commissions, the clearer the better. Last thing we want to do is get in litigation where we're arguing about what something means. Ambiguity is what creates lawyers and makes lawyers very rich. Clear written documents, particularly commissions, will help avoid those issues. Bonuses is another big one, and they break down into two big parts, discretionary and non-discretionary. Hint, anything that is considered a discretionary bonus, you have absolute discretion of whether or not you pay it. So if it's a discretionary bonus, there's no entitlement, there's no contractual right to it. You don't have to pay it to them if you don't want to. So it's best practices that an employer makes sure it's discretionary. Now, what does that mean? It's you create language around it, it's based off the performance of the company, your independent performance. What is non-discretionary? If you meet these objectives and send $10 million in business in the next 6 months, I'll give you $20,000. Something that is clearly objective that we can all look at and say, oh, if I do X, I get Y. If there's some more touchy-feely subjective analysis, we think we're going to do well, or you're performing well, or your business is performing well, or your employees are performing well, then maybe we'll give you a bonus. That's the kind of language we want so that the employer has the most leverage and opportunity to evaluate how to pay those bonuses. All right, I am done with those slides, and I think there's a few other questions. Go, Jim.
Well, no, I think Michael has at least one that hasn't been answered.
All right, are there certain direct or indirect protections a small business owner can put in place to prevent false overtime claims? Yes and no. So what does an employer do to mitigate against these off the clock claims? First, have a handbook. What does the handbook need to have in it on this perspective? Clear rules around timekeeping, clear rules around no off the clock work, clear rules about anytime you engage in compensable work, you are expected and required to tell us and get paid for it. 4, clear rules that if you work unauthorized overtime, we will pay you. You will get paid for it. You will also get disciplined. Second, time records. The single biggest important record that you can have as an employer when it comes to these. Have clearly kept, consistent time records that an employee is expected to clock in, clock out, whether it's for lunch or not, so that you can point to those records and say, hey, Johnny, you said you were here at 8. Now you're filing this lawsuit saying you're at 7:30. These rules said you had to sign in right when you got here and get working. And if you didn't do that, you weren't going to get paid for it. You knew that. And you also weren't supposed to engage in work without asking to get paid. So what's the gist here? And you've just thrown a significant doubt in the reasonableness of the analysis of that, of those off the clock claims. There's other things you can do, depending on the type of business, you may want to have like security cameras. You may require other ways that the employee has to indicate they're at work. So security doors have to clock in. There's other ways to do these kinds of things. But happy to talk through it. It's a complicated issue. What other questions, if any?
We got one more, just popped in.
If we want to offer their employees commissions based on the company performance, how might an owner structure without them realizing the amount we banked? Seems overly transparent. Good question. Here's the answer. You say to a business, generally concept is we're going to give you a bonus based on the performance of the company. And, usually the way you do it is you do a target percentage of their base. So let's say they get, $70,000 and you have a base target bonus of 40%. So that means that employee has a max bonus of potentially 28,000. But how much they get is dependent upon the jobs, the company's performance, their individual performance. We've now created a discretionary bonus, which gives you the most flexibility. And B, you don't have to disclose how well the company did, because it's all based on how well you think the company did. And they know exactly they can get from 0 to 28. And the other benefit is if they did really great, you're going to give them 28. The company did great, you're going to give them 28. You may even give them 35. But if they haven't done super great, or you haven't been super successful, you're going to give them 5. And you're going to explain that, because that's a learning opportunity that you can deal with that employee on why they're not getting their 40%. And here's the reasons. And you can lay that out. And now that gives you the opportunity to talk through how we can achieve that bonus next year and walk through those reasons. Anything else I can help answer?
It
it looks like it's 8 p.m. That's pretty good.
Yeah, this was great. I can tell you, going back to my years of, running a business with 250 people, these are great issues. These were great questions, and you answered them wonderfully. As an operator, we got one more. See that?
I do. How much money these agreements? So it depends on what lawyer you're asking and what kind of things you're doing and the complexity of it. But I would say to get a decent contract, like on confidentiality covenants, those things, to get a template. So the idea is something that you don't need to go back and ask Joe Schmo lawyer how to do it. It's going to be about $1,000 to $1,500 is what I would estimate it costs. You can get templates and things at various online legal services. The challenge with those is they're not tailored to your business, and then that throws into question the enforceability of those. But a good lawyer, that's what they're going to cost. But the savings on that, you pay a lawyer $1,500 to get a good contract. That's a heck of a lot better than paying a lawyer $60,000 to litigate over something.
Okay.
I don't know who's asking that question. Why don't we talk offline? I'll walk through that with you. I'm happy to be transparent about costs.
Yeah, and for everyone who wants to reach out to Walker, I put his email address in the chat. And when you send him an email, he'll send you back a link to schedule time with him. It's a very simple and easy procedure.
Yes. Yeah, I have an online calendar, schedule 15-minute sessions. Happy to jump on with anyone.
Yeah. One of the things I'll just share in my years of working with advisors, primarily lawyers, bankers, et cetera, accountants, you want somebody who knows the law or whatever topic it is, but also one that is easy to ask questions of, is patient with their time, and gives you clear answers that answers your particular situation. So, okay, somebody's asking for your email address. So let me put that in here again. And other than that, I just want to thank everybody for attending tonight. You've been a great audience. We appreciate your participation. Diane, want to thank Arlington Heights Memorial Library for requesting this program and allowing us to bring this program to the attendees on this very important and vital topic. So thank you very much. We know that there were a lot of good questions and a lot of good takeaways from tonight. We will post a recording of this webinar in a couple days, so you'll be able to view it if you didn't get all the notes that you wanted. And of course, you can reach out to Walker. And one last thing, please, if you have questions, check out your local library. Arlington Heights Memorial Library is a fine example, but there are wonderful libraries throughout the United States, and they are a fountain of information, and they are very underutilized by the business community. And with that, Walker, thank you very much for this evening.
Thank you for the opportunity.
The time. And John, thank you for posting in a few comments and helping us with the Q&A. Good night, everyone, and we hope to see you at another webinar. We've got John's webinar coming up on October 20th, and you can check out our website for that information. Thanks, everyone.
Thanks, guys.